Hi all my students of standard 10. Here I am back again with you to continue with our the judiciary of our history civics. Okay, so let's continue from where we left the last time. The last time we left was at judicial review, and the Supreme Court can declare a law ultra virus. I had explained to you that in the last module that a law can be declared null and void by the Supreme Court if it is not in keeping with the letter and spirit of the Constitution, or it contravenes any provision of the Constitution. This is called as the judicial review, the power of judicial review, which is being given to the Supreme Court in its original jurisdiction. The Supreme, so let's, and I told you that you have to have a minimum of 5 judges to be able to declare a particular law as null and void. It cannot be the judgment of one judge. Okay, and of course the CJI has to be a part of the 5 judges. The Supreme Court has the power to review all national and state laws and executive orders and declare them null and void if they go against the provisions of the Constitution. For example, in the 1970 Supreme Court had declared the following acts of the Parliament as null and void. Which were they? The first one, it was a presidential order concerning derecognition of the former princes. Then the Banking Companies Act 1969 for the nationalization of 14 banks. In August 1999, the Supreme Court had held that merit should be the sole criterion for admission to the postgraduate and other higher courses in medicine and engineering. So there was this law, you have this reservation for particular classes and all, but the Supreme Court in August 1999 said that whenever you want to have an admission, or whenever for a postgraduate level course or a higher course in medicine and engineering, if it is one of these courses, then it has to be based only, the criterion should be only merit and not anything else. Okay, so now what is the need for this judicial review? Why do we need to have this judicial review? The Constitution has provided for a balance of powers between the center and the states. If the union government or the state go beyond their limits, the Supreme Court can settle the dispute. That means if a law has been passed either by the union government or the state, which is not within their purview, which is not within their limits, which is not within their rights, then the Supreme Court has a right to review, means to take the judicial review of that particular law and declare it as null and void. In a written constitution, a law may be ambiguously worked. So there can be an ambiguous interpretation of a particular law because it is just a written constitution. The question of interpretation of the constitution is bound to arise, and only the Supreme Court has the power of original jurisdiction to give you the meaning of that particular law and to declare whether it is in keeping with the constitution or not. The legislature may not possess the wisdom, experience and impartiality which are needed to explain what the law means. So to be able to explain the law, maybe the legislation does not have these qualities because it's not an expert in the legal field, but the Supreme Court is an expert in the legal field. This function can be best performed by the Supreme Court, and therefore we say that there is a need for judicial review. Is that clear? Now we come to the court of record. A court of record is a court whose judgments are recorded and the evidence and testimony. The judgments are in the nature of precedents. I have already explained this meaning to you in the earlier module. The high courts and other courts are bound to give similar decisions in a similar case. They are not to be questioned when they are produced before any subordinate court. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Now, because it is a court of record, I have already explained to you the meaning of precedent in the module before this. So, apart from that, what can the Supreme Court do? The court of record has got two implications. What does it mean? That the judgments and orders are preserved as a record, as a precedent, and these can be produced in any court as a precedent. If a person commits a contempt of court, the court has the authority to punish him, and no authority can deprive the court of this right. So when you say that this court is a court of record, then it means these two things, that the judgments can be produced as precedents, and it can punish anybody who commits a contempt of court. Okay, so these are the two implications of being a court of record. Then we come to the functions of the Supreme Court. Original, on appeals, appeal by special leave. Now I have already explained to you original and appeals earlier. Let's understand the meaning of appeal by special leave. Okay, under Article 136 of the Constitution, the Supreme Court can allow a leave to appeal against a judgment of any court of India. It has a special power which can be exercised only under exceptional circumstances. So this special leave which you can take from the Supreme Court has got certain circumstances to be fulfilled. Everybody will not get that special leave. Okay, the Supreme Court has laid down the principles according to which this power of special leave can be used. Now when can this power be used? In civil cases, special leaves to appeal would not be granted unless there is a question of law or general public interest involved in the case. So if it is a civil case, then the special leave will not be given. I have explained to you what is special leave. When can the special leave not be given? If there will not be granted unless there is a question of law or general public interest. Only then you will get a special leave in a civil case. In criminal cases, the Supreme Court interferes when it is shown that exceptional and special circumstances exist and grave injustice has been done. There has been grave injustice, like I told you, reversal of the death cases and all. The Supreme Court could quash the decision of a tribunal. Quash means delete. Quash the decision of a tribunal when the tribunal has exceeded its jurisdiction or adopted a procedure which runs against the established rules of natural justice. So these are the three circumstances when the Supreme Court has laid down these three principles, that a special leave will be granted only in these three cases. Okay, now enforcement of fundamental rights. Any citizen whose rights are violated may move the Supreme Court for the enforcement of the fundamental rights. We've seen this earlier also. The Supreme Court has the power to issue orders or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of these fundamental rights. The Constitution prohibits the state from making any law which takes away the fundamental rights. If it does so, the law shall be declared null and void by the Supreme Court. So you cannot have a law which takes away or reduces, abridges over here means reduces in any manner the fundamental right of a citizen. If such a thing happens, then the Supreme Court can declare it as null and void. The important writs we have already done earlier. So with that we come to an end of this part of the judiciary, though of course I have done both the chapters 5 and 6 simultaneously. So but chapter 5 is absolutely over. Now as far as this is concerned, administrative and supervisory functions, this is not there in your syllabus. If you open to the first page of chapter 5, you will see that short, open to the first page where the picture of the Supreme Court is given. In fact, the Supreme Court picture is also on the very first page of your textbook. Okay, so you recognize the picture. Okay, so you open to the syllabus of your textbook and on that chapter 5, and in the syllabus you see the last thing they've given you is enforcement of fundamental rights and writs. Okay, this part, administrative and supervisory function, is not there in your syllabus. So with that I've finished chapter 5 in detail and a lot of chapter 6 also. But before I go on, continue with the High Court and its jurisdiction, there is one open your books to the exercises. Now you look at this question 1. What is a full sanctioned they've given you that Justice Alok Arade and Vipul M. Pancholi sworn in as Supreme Court judges. With the swearing in of these two judges, the Supreme Court returned to its full sanctioned judicial strength. This has been given in the Hindu paper on August 29 in 2025. Okay. Now, the question based on this reference is, what is the full sanctioned judicial strength of the Supreme Court? And then the MCQ gives you 30, 33, 34, 28. This is a choice given to you. Now, actually, what do you think would be the full sanctioned strength of the Supreme Court? We have done not more than 33 judges, correct? That is what your book has given you. If you are using this book which has been the latest book, okay, so 33, not more than 33 judges plus the CJI, so it totals to 34. So the full sanctioned judicial strength of the Supreme Court will be 34, but as per the latest revision of the Supreme Court, which was done in this year, during this year in May 2026, the Supreme Court full sanctioned judicial strength has become 1. That means the Chief Justice of India plus 37. So as of today, we actually have 38 judges in the Supreme Court. So if you get an MCQ with an example of 38 given to you, please remember that 38 is also the right answer. Okay, and of course 30, 33, 34, 28, if that is the choice given to you, then 34 will be the right answer. So in May 2026, we had 1 CJI plus 33. So we have 38. Okay, your book says, according to the textbook, it is 1 CJI plus 33. So that is one question that I wanted to discuss with you. There is also another question which I want to draw your attention to, which is question number 8, which says, as a court of record, the Supreme Court has the power to punish for contempt of itself, confer titles to appellants, declare evidence as indisputable, and all of the above. Okay, now you have to choose from here. It's an MCQ. So the correct answer over here will be the punish for contempt of itself. Because read what is the question given to you. As a court of record. It's very clearly said a court of record, and we have just done that as a court of record, it has two implications. The first one is that the judgments are preserved as precedents, and the second one is if a person commits a contempt of court, it has the authority to punish him. So over here, that will be your choice. Okay, now you come to question number 13 and 14. Turn the page, come to question number 13 and 14. See the questions given over here. Select the option that shows the correct relationship between statement 1 and 2. Now statement 1 is given to you as both the judiciary and the executive are involved in the appointment of judges of the Supreme Court. The second statement is every judge of the Supreme Court is appointed by the President of India in consultation with the judges of the Supreme Court and High Courts besides the Council of Ministers. Okay, that is the reason why I keep doing Supreme Court and High Court together. Both the questions, even the High Court is involved. So I've just drawn your attention to these questions, and I've given you the first answer, which I want you all to remember, so that in case there is a tricky question put to you, you should be able to write your MCQ without any problem. So in the next module, we will continue with the jurisdiction of the High Court. Or I think we can continue this now because I've hardly taken your lecture for 13 minutes. So I think we can continue. So let's continue with the jurisdiction of the High Court. It's very similar to the Supreme Court with a slight change. First of all, we come to the original jurisdiction. First of all, I want to tell you all that totally in our country, in India, we have got 25 High Courts. There is a total number of 25 High Courts in India at the moment. Okay, some of the states, they share the High Court. Let's read. Power and jurisdiction of the High Court. The jurisdiction of a High Court of a state extends to, so what is the jurisdiction power? The territorial limits of that particular state. If there is, so that is the first point. It extends to the territorial limits of that particular state. If the High Court is common. If there is a common High Court between two or more states or union territories, then the jurisdiction of that court will extend to the territorial limits of both the states or the union territories. Okay, so this is the jurisdiction of the High Court. Okay, then we come to the High Courts have original jurisdiction. High Courts have original jurisdiction, the power to hear and decide cases in the first instance, when the original jurisdiction over matters relating to state revenue and its collection. So if there is any matter relating to state revenue, you do not go to the lower courts, you go straight to the High Court of that particular state, because it is concerning the state revenue. You cannot go to the Supreme Court. You have to go to the High Court of that particular state. So that comes under the original jurisdiction of the High Court. Am I clear? Okay. I'll explain it again. Original jurisdiction means that the court, what I've explained to you in Supreme Court, similar will be the case over here for the High Court. The High Court has got the original jurisdiction over particular matters. Wherever there is a dispute regarding the state revenue and its collection, then you have to go to the High Court of that particular state under its original jurisdiction. You cannot go to any other lower court than the High Court, because it is a matter of state revenue. Then if you come to the cases regarding wills, divorce, marriage, company law and contempt of court, may be referred or brought before the High Court directly. You can come to the High Court directly if you want. Then every High Court has the power to interpret the Constitution, just like the Supreme Court. This power is known as the power of the judicial review. But if you are not happy with its interpretation, or if the High Court feels that it needs to refer a particular case to the Supreme Court, then the High Court will refer that case to the Supreme Court and ask it to give its judicial review regarding the interpretation of the Constitution. Otherwise, even the High Court has got a power of judicial review. Okay, so it can also interpret the Constitution. Along with the Supreme Court, it enjoys the original jurisdiction for the enforcement of fundamental rights guaranteed to the Constitution. So again, this is a similar original jurisdiction with the Supreme Court, that even the High Court has got a right to issue writs. That means the fundamental rights can be protected even by the High Court of that particular state. It can also issue writs for the enforcement of the fundamental rights. So these two are the overlapping ones. Okay. Then the High Court has a jurisdiction in cases such as election petitions challenging the election of members of the parliament or a member of a state legislative assembly or other local bodies. Children, please mark over here that all this is with regard to a particular state. Therefore, you go first to the High Court. You do not go directly to the Supreme Court. These matters will come to the High Court first. Which matters? Election petition, which is challenging the election of a particular member of a parliament. So if somebody has been elected to the parliament, and if you want to challenge that election, then you have to go to the High Court of that state, or a member of the state legislative assembly or any other local body. If you want to challenge that the elected persons, then you have to go to the High Court of that particular state. So this is all in its original jurisdiction. So it has got two overlapping original jurisdictions with the Supreme Court. Now we come to the appellate jurisdiction. What is the appellate jurisdiction? It means same. We have done the same thing in Supreme Court. It means the same thing over here, with the difference that it comes from the district courts. Okay, the appellate jurisdiction of the High Court means that the High Court has the power to accept appeals against the decisions of district courts in civil as well as in criminal matters. You have a chart over there on your page which shows you that there are 25 High Courts in our country, which I told you in the beginning that there are 25 High Courts. That whole chart has been given to you. This chart is only for your reference, for your knowledge, just to increase. You can read it once. You are not supposed to learn it by heart. Okay, it's there for your reference. So we come to the appellate jurisdiction in civil and criminal matters. Decision of the district court. Now the civil cases. What happens in the civil cases? Only those civil cases which are decided by the district courts under the jurisdiction of the High Court concerned can be brought to the High Court by appeal. So obviously, so if the district court is within its jurisdiction, so if you are talking about the of a particular state and a particular high court, if you are talking about the state of Maharashtra, then the district courts in Maharashtra, if they have given a particular ruling or a judgment, then you will come to the Maharashtra High Court, which is in Mumbai. You cannot go to the Gujarat High Court. Have you understood? So the district court of that particular jurisdiction will come to that particular court, that High Court. Okay. In matters concerning the land revenue and in cases where blatant injustice has been committed by any tribunal, in such cases the High Court may quash the order of the tribunals. So these are the civil cases where the High Court can be an appellate court. Then we come to the criminal cases. What are the criminal cases? In criminal cases, the appellate jurisdiction consists of appeals, isn't it? Which are the appeals against the judgment of a sessions court, sessions judge or an additional sessions judge where the sentence of imprisonment exceeds 7 years. So if the additional sessions judge, you have to refer to the first diagram which I had given you in the very first module where I have given you a whole chart, isn't it? It's given to you in your textbook also. I've already given it to you earlier, so you will know which judges we are talking about. I'm not repeating it. So if the sessions judge or the additional sessions judge has given a sentence of imprisonment for more than 7 years, then you can appeal to the High Court. This is the criminal case. Okay. Then the second one, the judge against the judgments of the assistant sessions judge, chief metropolitan magistrate or other judicial magistrate where the sentence of imprisonment exceeds 4 years. So if these people have given if you notice in your book, you have got who comes under which see the criminal cases, turn your page, you will find it. In criminal courts, you first have the you have the sessions judge or the additional judge. Then, so if they give a sentence of more than 7 years, you can go to the High Court. Similarly, the metropolitan judge, the second class judicial magistrates, if they give an imprisonment sentence of more than 4 years, then you can go to the High Court. Then you can also go to the High Court against a state when the order of acquittal is passed by a sessions judge. So against the state. So what happens over here is, if the order of acquittal has been passed by a sessions judge, then you can go against the state and say that this is not the correct order. It needs to be an appeal lies in such a case. A sentence of death must be confirmed by the High Court before it can be carried out. So if anybody has given a sentence of death to a particular accused, then you have to go to the High Court first. The High Court has to confirm that sentence of death, only then it can be carried out. Is this clear? Okay, now we come to the advisory jurisdiction. Just like the Supreme Court, it can also advise. But whom will it advise? Here there is no precedent. In the state, we have seen that as far as the state is concerned, the High Court comes into the picture. So in the state, we have the governor. So if the governor wants to ask a question, then he will ask to the Chief Justice of that particular state. Okay, Chief Justice of the High Court. So the High Courts can advise any government, department, legislature or the governor if they seek it, if they ask for the advice on constitutional as well as on other matters of law. Their advice is not binding on the agency seeking such advice. Very similar. Then we come to the revisory jurisdiction. Now what do you mean by revisory jurisdiction? I've explained it to you already earlier when I was doing the Supreme Court. Revisory jurisdiction means that the High Court can call for the record of a case which has been decided by a subordinate court. This is done because the High Court feels that the subordinate court has exercised a jurisdiction which is not vested in it, or that the latter has not followed a proper procedure. Therefore, the High Court can review the case and take appropriate action on it. This is known as the revisory jurisdiction of the High Court. So when the High Court feels that the subordinate court has not given a proper judgment or it has exceeded its jurisdiction, each court has its own jurisdiction limit. So if the High Court feels that this court has exceeded its jurisdiction, then it can call for the papers of that case, and then it can get the proper procedure followed, and it can take appropriate action on it, and this is called as the revisory jurisdiction of the High Court. When is this applicable? If there is injustice or an error of law apparent on the face of the record. So if the High Court notices that there is some injustice which has been done, or it is very obvious on the face that you can see immediately on the record that there is a mistake, an error has been committed, it will exercise its revisory jurisdiction. Violation of the principles of natural justice, arbitrary authority leading to wrong judgments, and there has been a flagrant error in the procedure. So in these 4 cases, a revisory jurisdiction of the High Court is allowed. Did you understand this? The revisory jurisdiction? The revisory jurisdiction in case of the Supreme Court is where the Supreme Court revises its own judgment because it feels there has been some error. A revisory jurisdiction of the High Court is it calls for the papers from another court where it feels, from a subordinate court, where it feels that a proper procedure has not been followed, or there is some blatant error that has been committed which is very, very obvious. Then it will call for those papers, and it will ensure that a proper judiciary that a proper judgment is given, okay, and which it is applicable in which 4 cases we have just read that. You have to learn this by heart, okay, by rote. Now we come to the judicial review. Like the Supreme Court, the High Court has the power of judicial review. If any law, executive order or ordinance passed by the state legislature or any other authority infringes the fundamental rights or contravenes any provision of the Constitution, the High Court can declare it as null and void. So in a judicial review, it is very similar to the Supreme Court, with the difference being that the Supreme Court declares the acts of the Parliament as null and void, whereas the High Court will declare as null and void the acts of the state legislature if it contravenes the Constitution. The High Court can declare it null and void. The High Court may withdraw a constitutional case from a subordinate court and deal with it or send it back with its directions. Is that clear? Okay. Then the 42nd Amendment of 1976 introduced provisions where the power of the High Court to judge the constitutionality of a state law was withdrawn during emergency. But with the repeal of certain parts of the 42nd Amendment, the High Court regained its power of considering the constitutional validity of any state law or executive order or ordinance. So during emergency, this power of judicial review was withdrawn from the High Court, but then after the amendment, 42nd Amendment, it got its power back. Okay, so with that we come to an end of the judicial review of the High Court. Now the High Court is also a court of record because its judgments will be taken as a precedent for the lower courts of that particular state. Because remember children, the High Court deals with the state, Supreme Court deals with the country. So if the Supreme Court is dealing on a larger level, the High Court is dealing with its particular state. The judgments and orders are preserved as a record to be referred by its courts in future cases. They can be produced as precedents. The law laid down by the High Court is binding on all the subordinate courts in the concerned state. Please underline that, it is very important, and when you are learning your answer, please learn this line without fail. The law laid down by the High Court is binding on all the subordinate courts in the state concerned. So you cannot say that the High Court has passed this particular judgment, so the Supreme Court also has to pass it. No, for the subordinate courts. Okay. Because you will appeal to the Supreme Court if you feel the High Court has done, the judgment of an High Court can be appealed in the Supreme Court. So it cannot be a precedent for the Supreme Court. But it does not bind the other high courts. So the High Court judgment or the judicial review of the High Court of the state of Maharashtra will not bind the state of Gujarat. Have you understood? What has happened in Maharashtra is good for Maharashtra. What has happened in Gujarat is good for Gujarat or any other state that you may talk of. Okay, but both these judgments can be challenged in the Supreme Court. So the Supreme Court is supreme. Is that clear? The High Court can punish anyone who commits a contempt of its orders. So again, we have this, what we have seen in the Supreme Court as the implications of being a court of record. So what are the two implications? First of all, it becomes a precedent for the subordinate courts of that state, and also it can punish anyone who commits a contempt of its orders. So with that, we come to an end of this jurisdiction part of the High Court, and I think I'll stop this module over here. Functions of the High Court we will continue in the next module. Okay, so see you all again in my next module, where we continue with the subordinate courts and the functions of the High Court and all. Bye everyone, see you again next time. Here's your history and civics facilitator. It takes me time, because I'm so used to saying English facilitator all the time, because I have done a lot of modules on English. If you haven't gone through them, please do go through them. I've explained Julius Caesar, all the acts in detail, which are there for your ICSE, and I have also explained all your treasure chest stories and poems. Please go through the modules if you think the modules are helping you. Bye, and wish you all the best.